Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, a popular way of getting in touch is to give us a ring or send us a message, I should say, or on the mobile number which also appears at the bottom of the screen. On this show, I'm able to cover a vast diverse range of matters ranging from immigration law matters, family law matters, criminal law matters, personal injury law matters. So whatever your legal questions are, please do get in touch either by calling on the landline number and speaking to me live or sending a message on that mobile number which appears at the bottom of the screen. Now, sending messages in, WhatsApp messages, text messages, it's a very popular way of getting in touch with us. Absolutely fantastic. Please do continue to send your questions in. And even before we've come on the show today, we've had numerous immigration law questions coming in on that mobile number. I'm going to start going through that. But as I am going through that, please feel free to pick up the phone and give me a ring and speak to me live as well. A couple of very minor points before we get going today. On this show, sometimes we get quite complex matters. Sometimes I need to look at documents before I can advise you properly. Now, if it's the case that your matter is complex or I need to look at documents, it's not a problem. I can speak to you off air. I can have that more thorough discussion with you off air. And if needs be, I can have a look at your documents as well before I advise you properly in relation to your issues. And again, it's a service that we provide here, which is completely free of charge. So have no concerns, have no worries. Please do get in touch either on the landline number or a message to that mobile number there, which is at the bottom of the screen. Now, as I said, even before we've come on show today, come on live on the show today, we've had a number of questions coming in. So I'm going to start going through some of the questions that have been coming in today. Now, immigration law is always very popular in terms of messages that come in. So let's look at the first immigration law question that's come in. A question that comes up in practice quite often. Our viewer says, my current leave to remain, which is basically my visa, is currently on the 10-year FLR-FP route, family route. When can I apply for indefinite leave to remain? Do I need to wait for my current visa, which is the third extension, to finish, or can I apply as soon as I have completed 10 years under this route? Okay, popular question, even in practice. You would normally get a visa under the 10-year route if your circumstances are such that maybe you've come to the UK on a spouse visa, but there's been a problem with finances, there's been a problem with English, or you've been living in the UK and you've overstayed, you've managed to then get a visa to stay in the United Kingdom. So there are slightly unusual circumstances or problematic circumstances, should I say, which has resulted in you being given a visa under the 10-year route to settlement. So once you're in this 10-year route to settlement, obviously understandable, those people who are under that route are concerned about how long it's going to take before they can get indefinite leave to remain. Do they need to wait 10 years, or is there a way of shortcutting it? Can you get it quicker? Now, a couple of points on that. The moment, let's say you were an overstayer, and then you applied under this 10-year route, your time actually starts, if you are an overstayer, from when the first visa was granted to you under the 10-year route. So, for example, you were in the United Kingdom in 2014, you were an overstayer in 2014, you made an application based on maybe your spouse, your children, etc., and the Home Office granted your visa. So after a period of overstaying, you're granted a visa. Now, that's when your 10-year route starts, when you're granted a visa. So in this example, let's say the visa was granted in January 2015, after a period of overstaying. So when you're granted the visa in January 2015, you need to continue extending your visa every 2.5 years. But in terms of applying for indefinite leave to remain, that's going to be possible in January 2025, as soon as you've completed your 10 years in the United Kingdom. Now, sometimes what happens is, as you submit the application and you extend it, there's a long delay on the part of the Home Office in processing the application. So by the time you get towards the 10 years, you've actually got a visa card where the visa has still got a number of years left on it. So although you would have first got a 2.5-year visa, another 2.5-year visa, 2.5-year visa, and the last installment of the 2.5-year visa, by the time you're on that last installment of your 2.5-year visa, you're very close to completing your 10 years anyway. So what you need to bear in mind is that you need to count your 10 years from when you were initially granted the visa under the 10-year route. So that sometimes helps in you being able to get indefinite leave to remain a little quicker. Another thing that you need to bear in mind is you might be able to move from the 10-year route into the 5-year route. It depends. If your partner is British, then that may well be possible. So that's something you need to explore as well. If you're in the 10-year route, is it going to be possible for you to move into the 5-year route, which would make it easier, quicker for you to get indefinite leave to remain? So if I give you an example, somebody who gets granted a visa under the 10-year route in 2015, that's normally valid until, let's say, middle of 2017. So in 2017, you move into the 5-year route. The advantage of that is that your 5-year visa then starts in 2017. So in 2022, 5 years later, you would be eligible for indefinite leave to remain. So you've counted 5 years from when you've gone into the 5-year route. So in 2022, you'd be applying for indefinite leave to remain. You don't have to wait until 2025. So you need to look at whether there's a possibility in your particular circumstances of moving from the 10-year visa into the 5-year visa, because if that's possible and you get your indefinite leave to remain, you would get your indefinite leave to remain much more quickly. So in answer to your question, count your 10 years from when the initial visa was granted. 10 years from then. Don't look at when your current visa expires, because you do have the option to apply for indefinite leave to remain early. And obviously, as I said, people are concerned about being in this very long route to settlement. You might be able to move into the 5-year route, and if it's possible, and you need to, slightly complex area, you need to take advice from an experienced immigration lawyer. If you are able to move into the 5-year route, move into the 5-year route. That will quicken the process by which you get indefinite leave to remain. Now, a couple of months ago, there was some talk about people who are in the 10-year route who might move to the 5-year route. Very quickly, they would become eligible for indefinite leave to remain. That hasn't really materialized for adults. So for adults, the position still is, once you move into the 5-year route, you must complete 5 years in the United Kingdom. Slightly different scenario now for children. For children, it is possible for them to get indefinite leave to remain more quickly in certain circumstances after, even if it's a period of overstaying, after they've been in the United Kingdom for 5 years, or they've held leave to remain for 5 years, they may become eligible for indefinite leave to remain much more quickly. So you need to bear in mind the situation with adults and the situation with children is completely different in terms of the time you've got to do with valid leave before you become eligible for indefinite leave to remain. So hope that answers your question. As always, it's always good to hear from you. So please do pick up the phone and give us a ring on that landline number as well. Now, a couple more questions that have just been coming in as we've been on air. Nationality question, always popular topic on this show. Now, the application that's been referred to here is a nationality application. A question that's been posed is, I am considering applying for indefinite leave to remain. I have indefinite leave to remain at the moment. I'm considering applying for nationality. Sorry, I should say. Considering applying for nationality. I have indefinite leave to remain. when can I apply for nationality? It's quite a long question, but let's go to our first caller for the day first. Hello, Assalamu alaikum.
वालेकुम सलाम बैलेंस क्या हाल चाल ठीक हो
जी अल्हम्दुलिल्लाह ठीक ठाक है. आपकी तबीयत कैसी है? ठीक है.
शुक्र अल्हम्दुलिल्लाह तो मैं इंशाल्लाह 9 के बाद आपको बात करेंगे तो अभी स्टूडियो में
जी 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 आप लाइव बात कर सकते हैं. जी स्टूडियो में है. जी
ओके 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 तो ये बताएं कि एक है दूसरा स्टूडेंट इधर मेरा दोस्त एक आया हुआ
जी
उसको 3 महीने उसका वीजा रहता है
जी
तो उसको कोई स्पॉन्सर मिल जाए तो क्या उसका वीजा लग जाएगा या मतलब कितनी देर का लगेगा तो उस स्पॉन्सर वाले का उनको मतलब उसको क्या देना पड़ेगा या वो टैक्स कितना होगा ये आप इन्फॉर्मेशन दे सकते हैं
जी जी दे सकते हैं. वो पॉसिबिलिटी है अगर कोई बंदा यहाँ है स्टूडेंट
जी
वीजा के साथ तो पॉसिबिलिटी है कि वो भी स्पॉन्सर्ड वर्क में ट्रांसफ़र कर सकता है. जो स्किल्ड वर्कर वीज़ा है इसमें ट्रांसफ़र कर सकता है. और 3 मंथ्स जो है ना मोर देन
ओके
इनफ टाइम है उसके लिए वो करने के लिए. मोर देन इनफ
ओके
टाइम. तो भाईजान उसके पास कोई स्पॉन्सर है अभी कोई उसको जो,
ये स्पॉन्सर एक आदमी से बात हुई है वो स्पॉन्सर ले रहा है उस
जी दे रहा है ना. सो पॉसिबिलिटी है कि उसको काम मिल जाएगा ना.
ओके
तो अगर कोई उसको स्पॉन्सर करने के लिए तैयार है तो बिल्कुल हो सकता है कि उसको यहाँ वीज़ा मिल जाएगी. वो स्किल्ड वर्कर वीज़ा के रूट में 100% हो सकता है. इनफ टाइम है. और जिसके पास टाइम भी कम है ना तो वो भी
जी जी
वो भी उसके पास भी पॉसिबिलिटी है. एक रास्ता होता है जिससे थोड़ा सा टाइम ज़्यादा मिल जाता है ये सॉर्ट आउट करने के लिए. तो भाई साहब अभी हम थोड़ा सा ब्रेक के लिए जा रहे हैं. अगर आप ब्रेक के बाद फ़ोन कर दें या तो होल्ड करें तो इंशाल्लाह इसके बारे में हम ज़्यादा डिटेल में
ओके
बात.
मैं ब्रेक के बाद फोन करूंगा
जी जी आप ब्रेक के बाद फ़ोन करो. आपका क्वेश्चन बड़ा इंटरेस्टिंग है. हम थोड़े से
ओके
डिटेल में बात करते हैं.
जी ब्रेक के बाद फिर 9 के बाद ही मिलते हैं
जी ठीक है. नो प्रॉब्लम. Taking a short break. We'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, a very popular way of getting in touch is to send us a message on that mobile number which is also there at the bottom of the screen. Just before the break, we had a caller who was inquiring about the possibility of somebody here in the UK on a student visa transferring to a skilled worker visa. And our viewer was explaining that there was a possibility that the student would be given sponsored work in the United Kingdom. And the viewer was asking about the possibility of transferring from a student visa to a skilled worker visa. And I did advise our brother who'd called in that we were about to go for a break. So if he did want to call back, I could elaborate on my answer and give further details to him as well. But in principle, somebody on a student visa, somebody with another type of visa can transfer within the United Kingdom to a skilled worker visa. It has been made much easier for people to transfer into this route. And what used to be the case before was that very limited category of people could transfer into the skilled worker route. Certainly with students, they had to have graduated from a UK university before they were able to transfer into the skilled worker route. That is no longer the case. More or less the position is that anybody who's in the United Kingdom, as long as they're not in the United Kingdom on a visitor visa, is able to transfer into the skilled worker route. And with this particular question, our viewer was explaining that the job that's been offered is with a care home, a health care visa. Absolutely fine. It doesn't matter whether it's a healthcare visa or it's employment with another organization, a normal employer. Has no bearing. It's still possible to transfer into the skilled worker visa as long as you have a sponsored sponsor license holder employer who's willing to sponsor you under their license. So that is absolutely possible. Now, I think we've got the caller back. Hello, Assalamu alaikum.
इस्लाम अलियास भाई, एक दोस्त मेरा वो केयर होम में काम करता है
जी जी।
तो क्या उस भाई को वो स्पॉन्सर वो अब उसने अपने उधर काम होम ऑफिस केयर होम वालों से वो बात की है, वो स्पॉन्सर उसको दे रहे हैं, क्या उसको कौन कौन सी चीजें चाहिए अपनी तरफ से और वो कौन कौन से पाकिस्तान उसका भाई वो टेस्ट करने हैं, ये थोड़ा सा प्लीज बता दें।
तो बस इसमें जो केयर होम है ना, उसके पास लाइसेंस है अभी या नहीं है?
या लाइसेंस है, लाइसेंस है,
लाइसेंस मिल गया है ये?
या
ओके, सो फर्स्ट जो सिचुएशन रिक्वायरमेंट है ना, वो तो फुलफिल हो गई कि लाइसेंस है। तो अगर कोई यूके में एज अ स्टूडेंट है, राइट, तो एक तो उसको इंग्लिश का टेस्ट पास करना पड़ेगा।
ओके।
समटाइम्स क्या होता है कि उसके पास जो इंग्लिश का जो क्वालिफिकेशन होता है ना, वो समटाइम्स वो एक्सेप्टेबल नहीं है स्किल्ड वर्कर वीजा के लिए, तो उसको समटाइम्स इंग्लिश का टेस्ट पास करना पड़ता है फर्स्ट ऑफ ऑल, राइट?
ओके।
इसके अलावा तो और तो कुछ उसको करना नहीं पड़ता। जो केयर होम है वो इसको वो कहते हैं सर्टिफिकेट ऑफ स्पॉन्सरशिप कोर्स, तो उसको केयर होम वाले उसको सर्टिफिकेट ऑफ स्पॉन्सरशिप देते हैं। तो ये बेसिकली कॉन्फर्मेशन होता है कि ये बंदे को हम स्पॉन्सर करना चाहते हैं।
ओके।
तो अगर ये सर्टिफिकेट ऑफ स्पॉन्सरशिप ये जो स्टूडेंट है उसको देते हैं, असाइन करते हैं, तो इसके बाद वो स्टूडेंट वीज़ा के लिए अप्लाई कर सकता है। और जब वो बंदा जब वीज़ा के लिए अप्लाई करता है ना, तो मेन उसका रिक्वायरमेंट यही होता है कि उसके पास इंग्लिश का क्वालिफिकेशन, राइट क्वालिफिकेशन होना चाहिए। इसके अलावा उसको कुछ और नहीं चाहिए, कुछ नहीं चाहिए उसको जो मेंटेनेंस है ना कि बैंक में सेविंग्स है या नहीं, वो भी बताने की जरूरत नहीं है, बिकॉज एम्प्लॉयर नॉर्मली ये कहता है उसकी जी सर्टिफिकेट ऑफ स्पॉन्सरशिप में कि मैं खुद उसकी जो फाइनेंशियल रिक्वायरमेंट है वो मैं फुलफिल मैं खुद करूंगा। तो इससे क्या होता है कि ये बंदे को सिर्फ इंग्लिश चाहिए। और जो केयर होम है वो केयर होम से सर्टिफिकेट ऑफ स्पॉन्सरशिप चाहिए। ये दो चीज की सिर्फ जरूरत होती है। ये तो दो जी।
अच्छा, एक और क्वेश्चन ये है कि एक मेरा दोस्त है, उसने ब्रिटिश, उसकी वाइफ है, वो प्रेग्नेंट है, ठीक है, क्या कि वो वीजा डाल सकता है या नहीं डाल सकता?
तो इसमें है ना, जो अगर उसकी वाइफ प्रेग्नेंट है, राइट, तो जी इसमें क्या है कि जब बच्चा बॉर्न हो जाता है ना, वो बच्चा तो ऑब्वियसली ब्रिटिश होता है, यूके में बॉर्न होता है, ब्रिटिश होता है, तो वो बच्चे की बेसिस पे उसको वीजा मिल सकती है,
मिल सकता है,
बच्चे की बेसिस पे उसको वीजा मिल सकती है। तो इसमें क्या है कि अगर वो बहुत पहले डाल दे और बच्चा बॉर्न नहीं हुआ है, तो ऑब्वियसली फिर मसला आ सकता है क्योंकि बच्चा नहीं है। मगर ये जो केस होते हैं ना, वो FLR FP, तो इसमें एक सिस्टम है कि आप जब केस डालते हैं तो आप फास्ट ट्रैक भी यूज कर सकते हैं, तो आपको स्ट्रेट अवे डिसीजन मिल जाता है। समटाइम्स बेस्ट ऑप्शन ये है कि बेबी जब बॉर्न, व्हेन द बेबी इज बॉर्न, तो आप वो फास्ट ट्रैक यूज करके अप्लाई कर लो और आपको वीजा स्ट्रेट अवे मिल जाएगी। वो बेबी के बेसिस पे वो मिल सकता है। ऑब्वियसली उसको बताना पड़ेगा कि ये बेबी और मदर के साथ वो रहता है, या तो अगर उसके साथ नहीं रह रहा है तो ये बताना पड़ेगा कि वो बेबी से मिल रहा है, बेबी के साथ कांटेक्ट में है। तो ये दो सिचुएशंस हो सकती है ना, एक तो वो टुगेदर रहते हैं, या तो फिर वो सेपरेट है और वो ब्रिटिश जो उसका चाइल्ड है उससे वो मिलता है। सो ये दोनों सेपरेट सिचुएशंस है, वो दोनों सिचुएशंस में यहाँ वीजा मिल सकते हैं। जी ठीक है, ठीक है ना, जज़ाकल्लाह है आपका कॉल के लिए,
थैंक यू
जज़ाकल्लाह आपका कॉल के लिए, थैंक यू। सो जस्ट बिफोर वी टुक दैट कॉल, वी हैड अ क्वेश्चन coming in regarding nationality, and in particular the question was, our viewer was saying that I have indefinite leave to remain in the United Kingdom. When can I apply for nationality? Do I have to wait a year before I apply for nationality, or can I apply straight away? Now, this is a question which actually comes up quite regularly. When can you apply for nationality after getting indefinite leave to remain? Whether it's straight away or whether you have to wait 1 year. The simple answer to that is it depends on whether your spouse, your husband or your wife is a British national or not. If your spouse, the person that you are legally married to, is a British citizen, then you are eligible to apply for a British citizenship straight away. So you don't need to wait for a year before you apply for British citizenship. Now, if you are married to somebody who is not a British citizen, or you are not married, then you would have to apply after 1 year of obtaining indefinite leave to remain. Now, if I give you an example, normally what happens is those who are in the United Kingdom on a normal spouse visa, generally you find that their spouses, not all the time, but generally you find that the spouses have British citizenship. So in, I'd say 95% of cases, what you will find is that the moment the person who's come from abroad and married the UK citizen, the moment they get indefinite leave to remain, the next step is that they apply for British citizenship straight away. So fairly straightforward. Contrast that with a situation where somebody is here on a work permit, skilled worker visa. They've got their indefinite leave to remain after working in the United Kingdom for 5 years. Are they eligible to apply for British citizenship straight away? No, because generally speaking, they're not married to British citizens. What tends to happen is that they are on a work visa. They might sponsor their partner who's abroad to come to the United Kingdom later on, or their partner from abroad might be here, but you normally have to wait for a year in those circumstances. Okay, thank you for that message. We'll take our next call. Hello, assalamu alaikum.
Walaikum salam, brother. How are you?
Alhamdulillah, good. How are you? You okay?
All right. Just one wee quick question regarding to the combined basically income. I'm a self-employed myself, right? So I just wondered, my wife, the visa going to expire April next year. So just wondering if how are we going to combine income, right? Because I'm self-employed and she just working part-time.
Okay,
so just wondering if she's go for example, working just like 3 to 4 months in a full year, right? So I'm obviously working from April to April, right? So how are we going to just try to when I clarification, how are we going to combine it both and together, self-employed or employment?
Okay. Now, one of the questions now is, do you know exactly when her visa expires? Because we just need to work out which tax year is going to be applicable to you. Do you know when the visa?
Right, so the visa basically expired in the 15th April 2023.
15th.
So obviously, I know it's 28 days grace period of time, right? So I could make an application on the 15 or 16 in the March.
Yeah. So you've got two choices actually. You could.
Sorry?
You've got two choices. You can pick your financial year. So you can pick 2022 to 2023.
2022 to 23.
Yeah.
So can I apply it? I see if I know I'm actually start from April to April, the 5th April to 5th April each year. But if I made the application, if I will make the application just before the 28 days before the visa gets expired, so this will
No. You can make the application 1 day before. It's not a problem at all.
Yeah, I get it. But if I do want to use the previous year,
so this is what I'm saying. If you do that, if you apply before, let's say you apply in March, then the financial year will be 2021 to 2022.
22, right? So how are we going to combine it basically, right? I'm just trying to figure in
Sure.
I don't want to make any mistakes. I just wondering, self-employed or employment, how are we going to combine with each other, right?
No
to
problem.
make it 18,600.
Yeah, no problem. So are you a sole trader or a partner, or are you a limited company?
A sole trader.
Sorry, are you a sole trader?
Yeah.
Absolutely fine. Okay. And when did your wife start employment?
Sorry, what did you say?
When did your wife start employment?
Started to work, did you say?
Yeah. Well, brother, we're just taking a short break. If you just hold on, we can go through
Yep.
this after the break. We'll
Yeah,
be
that's
back in the
fine.
next couple of minutes.
No worries, that's fine.
Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. We've got a number of callers waiting. Please do hold on. I will try and get to your call as soon as possible. Got a brother who I was speaking to before the break. Let's go back to him. Hello, assalamu alaikum.
Wa alaikum salam. Yes, brother.
So, brother, so what you need to do, you have a choice. You have a choice whether you want to pick 2021 to 2022 or
Yep.
you want to pick 2022 to 2023. You have a choice.
Right.
So you need to look at what works out better for you. Okay. Now, first of all, what's your income likely to be in either of those two tax years? What's your income likely to be?
My income range about the 15 grand a year.
Absolutely fine. So let's say it might be, I think, beneficial probably to use the recent tax year, 2022 to 2023, show your £15,000 and show your wife's income during that financial year. So from April 22 to April 23. What do you think your wife's income is going to be from employment in that period?
Right, sorry. So if I use, I just must, if I must interest you, if I do use 2021 to 2022,
I think
I should need to use the wife one, 21 to 22 as well.
No, yeah, you've got to use the same one, whichever one you go for.
Same year, right?
Yeah.
So there is any category wife need to work like if she work about, for example, just 3 months or 4 months and 1 year.
Absolutely
Does
fine.
that make any difference?
No, it doesn't. But it's at the time you make the application, she really does need to be in employment as well at that time.
Right.
So-
I get your point. Right. So how long she need to be obviously she employed by someone?
No, it doesn't matter.
Before I make the application to home office.
Does it matter? Because let's say you've earned £15,000 and let's say your shortfall is 3,600. So as long as she earns 3,600, she might start in December 2022, December, January, February, March. So in those 4 months, as long as she's earned that and is still employed, that's fine. She doesn't need to be employed from April 2022.
All right, okay. So she need to earn, and like, see, if for example, she had employment over the last 3 months, and if I got a shortfall 3,600, so if she make a 3,600 within the 3 months, that should be fine.
100% fine. Yep. And keep her employed as well after that.
Right. So there is need anything layer from employer right to attach with the.
Oh yeah, I mean the standard.
application?
Standard employer's letter, wage slips, and bank statements. That's the standard,
Bank
isn't
statement.
it? That's standard, isn't it?
Right, and that's like to see if the wage, see the money officer she getting, is that make any difference if she's getting cash in hand or need to be done transactions, right?
Oh, well, sorry, I didn't miss the last point you made.
Right, so I say like if she get wages, right, does it need to be transferred into her account, like
Ideally,
from her employer?
yeah, ideally into her account. If she gets paid cash, whatever the net pay is has to go into the account to the penny. If it's net pay.
Right, I got your point. Right. Thank you very much for it.
No problem at all. Thank you very much, brother, for your call.
Thank you.
Okay. Thank you very much for that call. Let's see. We've had a number of callers who've been waiting for a while. I do apologise. Let's see whether we've got our next caller on the line. Hello, assalamu alaikum.
Wa alaikum assalam.
Ji, brother.
How are you, brother? You
Alhamdulillah, good. How are you, brother? You okay?
Yeah, I just got a quick question, brother. My wife came to this country in 5 years base. So we applied 8 months ago to get remain in England visa, basically indefinite.
Okay.
They sent us back saying that she's going to get another 2.5 years visa because they refused it.
Okay.
Basically saying that her 18,600 is not completed for a year.
I understand.
If you're both working, then you should have at least 18,600. But the reason was that she was pregnant, so she started work late.
Okay.
But she's still working. So my question is, can we apply again after some time, or do we need to wait another 5 years now?
I think the problem is if they've now placed you in the 10-year route. So if you've been placed into the 10-year route, you won't be eligible to apply for indefinite leave now straight away. You're going to have to count 10 years really from when she came into the UK now to get indefinite leave.
Okay, so if they put in 10 years route, then you can't apply again.
No, because there's no point, the law as it stands, right? There's no point now going back into the 5-year route because you've done 5 years already. That another 5 years doesn't help you. You might as well stay in the current route and complete your 10 years. At the point where you are, if you're on the 10-year route now and it sounds like you're in the 10-year route, you might as well stay in the 10-year route. Now, there was some talk about the law being changed. It hasn't been changed. So there's nothing which says, or if you've gone into the 10-year route, if you go back into the 5-year route, we'll give you indefinite leave more quickly. That law is not in existence at the moment. You have to work on the basis that if you're in the 10-year route,
but law can change, like to the 5, like if you've done 5 years, if you came in 5 years route, I can understand that people are coming in 10 years route, that's different, but if the people are coming in 5 years route, the law can change for them.
100% it can change, but there was some talk of the law changing, but it hasn't changed.
It hasn't changed. Okay, and how long can you stay out the country?
3 months is not a problem normally. I think they've given more flexibility to those who are under the 10-year route. I think they're prepared to allow them to stay outside the UK for up to 6 months in a year. My personal view is 3 months per year is fine. Try and limit
3 months to a year, yeah?
Yeah, 3 months per year.
3 months per year?
Per year, yeah. It's not a problem.
Okay, no problem. Thank you, sir.
Thank you very much for that. Thank you very much for that call. Right, we've had a number of callers waiting. Let's see whether our next caller is still waiting to come on live. Hello, assalamu alaikum.
Hello, assalamu alaikum.
Ji, wa alaikum salam. Ji, bhai, thank you for calling.
Hello.
Hello, assalamu alaikum.
Wa alaikum salam ji.
Ji, brother, you're live on air.
Yeah.
Brother, I think you might be very close to the TV. If you just move back a bit.
Hello, assalamu alaikum.
Ji, wa alaikum salam.
ना मैं क्वेश्चन पूछना था, मैं एप्लीकेशन की थी तकरीबन 15 मंथ हो गए, लेकिन उसका जवाब नहीं सुना पाया जाना। बच्चे ने 7 ईयर ने बेस पर तो ईमेल भी की थी, लेकिन उनको जवाब नहीं दिया।
ओके, तो आपका जो फिंगरप्रिंट्स जो किए थे ना आपने, जो बायोमेट्रिक से, वो कब किए थे?
जी।
वो कब किए थे?
वो तकरीबन हो गए 10 मंथ।
जी, तो जब से आप फिंगरप्रिंट्स करते हैं ना, जो बायोमेट्रिक एनरोलमेंट कहते हैं, फिंगरप्रिंट्स जो आपके होते हैं, तो फिंगरप्रिंट
वो भी किए ना 7 ईयर की बेस पे।
जी, मैं समझ गया। जी। तो जब फिंगरप्रिंट्स करते हैं, वैसा बहुत आवाज आ रहा है बैकग्राउंड में। जब से आप फिंगरप्रिंट्स करते हैं, इसके बाद 12 to 13 मंथ्स लगते हैं। सो आपको ये देखना है कि आपने फिंगरप्रिंट्स कब किए थे। फिंगरप्रिंट्स के बाद 12 to 13 मंथ्स के बाद जवाब आता है। भाई साहब, आपको आवाज आ रहा है मेरा?
आपका आवाज आ रहा है
जी। सो फिंगरप्रिंट्स के बाद 12 to 13 मंथ्स लगते हैं जवाब के लिए।
अच्छा, अभी तो 15 होने वाले हैं।
अगर 15 हो गया ना, फिंगरप्रिंट से काउंट करना पड़ेगा।
अच्छा,
जब आपने अप्लाई किया ना, तब से नहीं, जब से आपने वो फिंगरप्रिंट
वो भी तकरीबन 12 मंथ के करीब हो गए।
हाँ, तो ये ठीक है ना, 12 to 13 मंथ्स उसका प्रोसेसिंग टाइम है ना।
अच्छा,
तो भाई आप ऐसे करो, आप देखो कि आपने फिंगरप्रिंट्स कब दिए थे और इससे लेकर 13 मंथ्स काउंट करो, तो वो टाइम पे नॉर्मली जवाब आता है भाई।
ओके, नो प्रॉब्लम। थैंक यू सर।
थैंक यू है, जज़ाकल्लाह भाई, आपका कॉल के लिए। थैंक यू वेरी मच इंडीड।
थैंक यू
है। Thank you. It's an interesting question relating to delay, and there is still a significant delay in processing these kind of applications. So we had a number of callers waiting. I don't know whether our callers have been patient and waited or not. I think couple of people have hung up. I do apologize. We had a number of questions, one after another, which meant that I couldn't get to your call much earlier. Now, sorry, just going back to our WhatsApp messages. Message that's come in. Let me read the question out. Salams, my mother-in-law is poorly. She is 65 years old, lives in Pakistan on her own. 2 sons, both in the UK. One of the sons has been in Pakistan for a few years to take care of her, leaving his family in the UK. Can we apply to bring her to the UK to take care of her? What visa would be applicable for her? She has lots of assets in Pakistan. Okay, it's a very common question where the children in the UK, mums abroad, what can you do? Options are quite limited. I will go into this in a bit of detail, but our caller has been waiting for a while. I'll just deal with that call and then come back to this. Hello, assalamu alaikum.
Walaikum salam.
Ji, bhai, thank you for calling. Ji, bhai, what's your question?
जी मुझे इनसे बात करनी थी वो डाइवोर्स के सिलसिले में
जी जी तो आप लाइव है ऑन है तो आप आपका क्वेश्चन पूछ सकते हैं जी
जी मैंने वो लिखा हुआ था कि D11 फॉर्म भर के
जी
को भेजना था
जी
कोर्ट में
जी जी आपको D11 फॉर्म भेजना था जी
जी तो वो भी इसका कितनी देर में जवाब आएगा
जब D11 वो डिवोर्स के बारे में बात कर रहे हैं
जी जी
वो D11 फॉर्म सो आपने डिवोर्स कब शुरू किया था
डिवोर्स तो मैंने 2 साल पहले किया था
कब किया था
इसका जवाब नहीं आया था
जी जी तो आपने जो डिवोर्स शुरू किया फिर वो वाइफ ने जवाब दिया या नहीं दिया
नहीं वाइफ ने जवाब नहीं दिया था बल्कि मैं इसका 2 साल पहले मैंने किया था और वो उसकी फाइल वापसी आ गई थी तो भी वो मैंने सही तरीके से देखा उसको मैंने तो वो फिर क्या मैं इसका 11 के बाद
सो वो जो डिवोर्स पेपर्स है वो वाइफ पर सर्व हुए थे या नहीं हुए थे वो डिवोर्स के जो पेपर्स थे वो वाइफ को मिले थे या नहीं मिले थे
वो मैं किसका
जी
नहीं वाइफ सबमिट नहीं हुई थी और क्या मैं इसका मैं दोबारा फिर अप्लाई किया
जी तो आपने अप्लाई किया था या वाइफ ने अप्लाई किया था
वो क्या मैं इसका ओरिजिनल मैरिज सर्टिफिकेट की वजह से I lost all certificate.
All certificate, right? Okay. तो फिर आपने कोर्ट को अप्लाई किया?
मैंने अप्लाई किया था.
Okay. तो कोर्ट ने क्या कहा? कोर्ट ने कोई जवाब दिया या नहीं दिया आपको? नॉर्मली क्या होता है कि आप जब अप्लाई करते हैं
जी मैंने ऑनलाइन बुक किया है इसको तो अभी इसे कितना टाइम लगेगा अंदाजन
नॉर्मली
नहीं कल किया मैंने
जी जी ओके भाई साहब अभी हम थोड़ा सा ब्रेक के लिए जा रहे हैं इंशाल्लाह ब्रेक के बाद मैं आपको थोड़ा सा डिटेल में जवाब देता हूं कि कितना टाइम लगता है for the benefit of our viewers we're taking a short break we'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, another popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. Now, just before the break, we had a caller who'd called in to ask a question regarding divorce procedure. He'd made an application to the court and he wanted to know how long it would take for the application to be looked at by the court. Now, couldn't quite understand what the application related to. It may be to do with the original marriage certificate having been lost. Now, in terms of the timing for applications to be considered by the court, if it's a specific application that you make, in my experience, you're unlikely to get a decision within a few weeks. The way things are at the moment and with the backlog that exists in most of our court system, you're looking, generally speaking, to get a decision on your application or to get a hearing within a couple of months. So the time frame generally is 2 months, 3 months for your application to be considered. It's not normally considered and you be given a hearing within 2 to 3 weeks. The more likely scenario is a couple of months for a decision. Now, if you're not sure about how long it's going to take, then you're better off calling the court directly and asking them what their current processing time is for applications. And generally, I tend to find that court staff are actually quite helpful, very knowledgeable as well. They're used to dealing with these kind of queries about timing, etc. And they can normally give you a good indication as to how busy that particular court is. They have an idea about where applications have got to, which applications they're working on, etc. So if the timing is an issue, then I would suggest that you get in touch with the court and get an indication from court staff as to how long it's going to take. Now, thank you very much for that question. Just before I took that call, had a question from a viewer, a sad question relating to a mother who is in Pakistan, who is around 65 or over 65, unwell. 2 sons in the United Kingdom. One appears to have gone back to look after mum, spent a bit of time there. Rest of his family are on their own in the United Kingdom whilst he's there looking after mum. Their ideal situation would be to sponsor mum to come to the United Kingdom and for her to obviously live, be cared for by the children in the United Kingdom. And I suspect that in terms of meeting mum's expenses between the 2 brothers, they would be able to do that. Now, there is a problem with this particular scenario in terms of solutions. There is a category that mother could apply under. It is called the adult dependent relative category. You can go onto the Home Office website and you can read up on that, the adult dependent relative category. In practice, it is extremely difficult to qualify for a visa under that particular category. The problem is this, that the requirements that need to be fulfilled, a few of them can be fulfilled, but there are 1 or 2 requirements which in most cases you'll find are impossible to fulfill. So the person that you're wishing to sponsor has to be your relative, not a problem. They have an illness for which they require personal care, fine. Maybe there's no family members in Pakistan who's able to provide that care. Again, easy to demonstrate in most circumstances. The difficulty is that you also have to satisfy the Home Office that the country where your mum lives, in this case Pakistan, there are no facilities there to care for mother. Now, most countries have facilities in place. So in Pakistan, in the cities, for example, Islamabad, Karachi, etc., there will be care homes, there'll be nursing care facilities. So the Home Office's argument normally is that we accept mother is unwell, she needs personal care, there may not be any family members to provide that care. We accept all that, but there are care facilities available in your home country, so she should be cared for there. And in terms of costs, the argument is that there are 2 sons who are British citizens, so they are able to meet the cost of care in mother's home country. That's the fundamental problem with this scheme, that it does exist, but the last requirement that there shouldn't be care facilities available in one's home country, that's virtually impossible to fulfill. Now, the way in practice that you might try and get around is to say, okay, I'm not sure about the circumstances here because we've just had a message in, but it may be that the way around it would be that with the particular illness that mother has, although care facilities may exist, the care facilities don't cater for somebody with that kind of illness. Now, I'm not sure whether this is the case or not, but I've been dealing with a case where somebody suffers from dementia, and the argument that we're trying to run is that there isn't care available for somebody who suffers from that kind of illness. Home Office's argument is that care facilities are available. Elderly people with those kind of illnesses can be cared for, and our argument is that appropriate care is not available. Now, it's not enough simply to assert and argue that these care facilities isn't available, or to argue that, mum is better off being looked after by family members, or we can provide the care that nobody else will provide. The Home Office won't accept those arguments. What you're going to have to do is prove that suitable care facilities don't exist. And again, even if suitable care facilities don't exist, how do you prove that? It's difficult to get a report from an organization which can give evidence or provide a report as to the facilities which are available in that country. Most countries don't have that. So there's no expert that you can go to and say, you're an expert on facilities available in this country. Can you provide a report that, bearing in mind mum's illness and looking at the available care facilities, can you provide a report which confirms that there aren't adequate care facilities for somebody suffering from the condition that mother is suffering from? Even if you're right on that, in my experience, it's difficult to get an expert report because that system really doesn't exist. I mean, in the United Kingdom, we have experts everywhere. It's easy to get expert reports from medics, from social workers, etc., probation workers, and so forth. But in India, Pakistan, it's sometimes difficult to get that kind of expert evidence which is required to demonstrate to the Home Office that care facilities don't exist. Now, generally, the Home Office will end up refusing the application. You then have a right of appeal. So you've got a second bite of the cherry, so to speak, if you're able to convince the tribunal that, yes, related to the person who's coming here, mum, she has an illness where she needs personal care. You've got medical evidence which backs that up. If you're able to convince the tribunal that adequate care facilities aren't available, you've got a second chance of being able to get the application through on that. Extremely difficult to succeed on those grounds, to be quite honest. It's an expensive process. Approximate fees are in the region of, I think, £3,000. Now, there is an alternative. If let me just give an example. If mother wants to come to the United Kingdom as a visitor, I know you've said she's got good assets. Mum could come to the United Kingdom as a visitor. She could be cared for. She'd then need to go back and comply with the visitor rules. That's one way of getting around that. It might be better to try and apply as a visitor using her assets, etc., demonstrating her financial circumstances, demonstrating that she would go back, and she simply comes to the United Kingdom as a visitor, is cared for by the family members. Mother then goes back, and then after a period of time comes back to the UK. Now, if while she's here her health deteriorates, then I have seen applications being made where a visitor's health has deteriorated. I've seen family members then make an application for further leave to remain on that basis, saying, look, things have got worse, simply can't go back. We're here, we want to look after mother. So I've seen that. So, in this particular situation, and bearing in mind the country that mother is applying from is Pakistan, my personal view is try the visitor route first. See whether she can come to the United Kingdom as a visitor. Because if she's able to come to the United Kingdom as a visitor, one is she can be quite cared for a short period. She can go back, and then a family member could go back and care for her there. And for example, if the situation, her health was to get worse, then it could be possible that she could apply from the United Kingdom while she's here as a visitor. But that may well be the best option. In my experience, it's very difficult to qualify under the adult dependent visa route. It's unlikely to succeed. So I wouldn't really recommend that as the first course of action. Now, hope that answers your question. In practice, we do come across that quite regularly. It is very unfortunate, but since 2012, when the law on this was amended, it's been extremely difficult to sponsor elderly relatives, parents, etc., grandparents to come to the United Kingdom to stay here with you. It was possible prior to 2012, but it's no longer possible anymore. Hope that answers your question. But thank you very much indeed for all the questions and all the calls that we received today. That brings us to the end of the show. Inshallah, we'll be back next week at the same time. Until then, Assalamu alaikum.